I want to go over the criminal scheduling order for the federal case against Jeremy Charles Dewitte for fraudulent income tax returns. This is going to be the process of being indicted and tried by the federal government if you're ever accused of filing fraudulent income tax returns. Jeremy Dewitte is a known serial police impersonator, an embezzler, a child predator, a whole bunch of things. But now we've been finding out that he's probably cheating on his taxes by underreporting his income. And this is the process. He was just arraigned right now, which means the government looked at his tax returns. It looked suspicious. They tried to talk to him about it. His answers were suspicious. They gathered a bunch of evidence, which basically makes it look like he's very guilty. They presented that to a secret grand jury, which agreed that he looks pretty guilty. So they got the approval to move forward with a federal trial, which they've just brought him forth on today. And during the first day in trial, actually, I shouldn't say trial. It's probably a court case right now. He's going to take it to trial, but he is currently given a criminal scheduling order. And this tells us what the process is in federal court when you get tried for crimes such as tax fraud. Number one, this says within 7 days, Jeremy and his public defender can elect not to request disclosure. Now, I'm not exactly sure why a defendant would want to not participate in disclosure. It could possibly be because they don't want to have the obligation of reciprocally disclosing documents, objects, or reports to the prosecution, which is basically, I think, what it says in paragraph 2 here. It looks like it also goes for disclosing expert witnesses. And it also says that if you file an opt-out notice, then it relieves the government of its obligations under Section E and G of this order. Let's scroll down there real quick. So that means that the government won't have to disclose to you within the required 14 days any documents and objects or reports and examinations and tests like expert witnesses that might be used against you. So that's interesting. Let's go back up here. Moving on to paragraph B. It's basically saying now that the government is going to provide you as a defendant, Jeremy Dewitte, within 14 days a bunch of stuff, which includes oral statements that the defendant has made to an interrogation by any person that was then known to the defendant to be a government agent, like when he talked to the feds. So anything that the government might use at trial is going to be disclosed to him within 14 days, and that is the same with any written or recorded statements that the government has obtained against him. Again, it's a 14-day period where the government will be required to provide all that stuff to the defendant. They'll also be required to provide evidence of your prior record if they're going to be using that at trial, which means your past criminal history. Plus, within the same 14 days, they're going to give you a bunch of documents and objects, which means any like actual books or papers or documents or photographs or objects, vehicles, vessels. They give you access to that so you can inspect it and help you form a defense, especially if the federal government's going to be using it at trial against you. Same thing goes with reports of examination and tests, as we've talked about, and the expert witnesses. And with the expert witnesses, it's basically going to have to be a written summary that the government provides the defendant with, a written summary of any testimony that the government intends to use. And that summary is going to describe any witnesses, opinions, and bases for the reasons of the opinions. Then they're going to give you a bunch of documents, access to documents about electronic surveillance that they've done, such as wiretapping or consensual monitoring or body wires or tape recordings or transmission devices, videotape recordings, bake surveillance recordings or pen registers, or mail covers that were conducted by law enforcement officers or witnesses in investigating this case. Now, if you don't know, a mail cover investigation is a law enforcement investigative technique in which in the United States Postal Service, they use the United States Postal Service, acting at the request of a law enforcement agency, they record information from the outside of letters and parcels before they're delivered, and then they send that information to the agency that requests it. So any mail that Jeremy Dewitte was getting, any mail that anybody is getting, is actually being scanned by the USPS, and they keep a record of all that. And then law enforcement agencies can use these mail cover investigations where they can go back and look at all the mail that was received at a certain address, because it's all been cataloged. So anyway, you get access to see what they are going to use against you from that. And then this Rule 404B evidence says within 14 days, the government's going to disclose any other crimes or evidence of wrongdoings or acts that they intend to use against you at trial, other things that you've committed illegally or been doing. And it says here, the government's written disclosure shall characterize the defendant's specific prior conduct to a degree that fairly apprises the defendant of its general nature. And of course, it says all this stuff has to be disclosed to the defendant before trial, otherwise it can't be used at trial. The government will also give you access to any confidential informants. They'll disclose those to the defendant. Actually, they'll disclose whether or not they have used confidential informants. And they'll disclose within 14 days, they'll tell the defendant of any names of any unindicted co-conspirators, maybe like his wife or something like that. They also have to disclose any conflicts of interest, which says the government shall alert Jeremy Dewitte's counsel if the government is aware of any potential conflicts of interest in the representation of the defendant by such attorney in this case. It looks like right after they send you in for your initial arraignment, within the next 2 weeks, they're going to give you a big document dump, and that's when everything's going to be happening very fast with the federal government. They'll also disclose whether you've been identified in any lineup or photo stuff. They'll also specify to you all items seized from you for evidence that they might introduce at trial. They'll also give you any rough notes. Actually, that's not what it says. It doesn't have a 14-day time period. It just says the government shall advise all law enforcement agents and officers involved in this case to retain any rough notes, recordings, reports, and statements pertaining to this case which now exists. So whereas for it used to be an investigation, now it's actually a case. So make sure you don't get rid of any notes or anything, it'll say. And that order must go out to all the law enforcement officers that were involved in the investigation of the case. And it also says here that the government is forbidden to destroy any evidence in the case or get rid of any evidence without giving 14 days notice to the defendant, giving Jeremy the chance to object. This is where they get rid of their notes and say it was before they got the order. That way it wasn't destruction of evidence. It also informs you that you have the speedy trial, of course. Then it goes into some of Jeremy's obligations. If he is going to claim an alibi or use insanity or some sort of mental condition, he needs to tell the government that within 14 days. It also says if Jeremy does do any discovery and he gets documents or objects or reports or examinations or tests done or expert witnesses, he needs to inform the government of that within 14 days as well if he's going to use it at trial. So he will have to abide by, the government's own rules as far as sharing information. And then there's a Brady rule here, which basically says that if the government is going to use the testimony or something of a law enforcement officer that's been admonished negatively by the system, as maybe on the Brady list or something, they need to disclose that to Jeremy within 30 days. And then there's the Giglio rule. Of course, we all know this is Giglio material, which basically says that within 14 days, there has to be if there's any exculpatory or impeachment evidence, that needs to be disclosed by the government if they think that evidence is material to the guilt or punishment. And it says here, for example, if they're going to use a witness against Jeremy Dewitte, they need to provide Jeremy Dewitte the witness's criminal history if that criminal history is relevant, like if he has a known history of lying. That could be used to impeach the witness, so that government, if they know about it, they need to disclose that. And then the other one is, the next one is the jinx The Jenkins Act material, which we all know, it requires a trial judge, upon motion by the accused, to order the government to disclose prior statements of its witnesses that are related to the subject matter of their testimony after each witness testifies on direct examination. We all know that. And that looks like it goes for all parties. They need to comply with that. It also says that both parties have a duty to disclose if they come upon any new evidence or material which is subject to discovery. They need to share that with the other party. It also says that both parties can agree to an extension. And it says the court recognizes and encourages the tradition of agreement and cooperation amongst counsel in discovery and inspection without the court even being involved. And it says without the need for a court order, both parties may agree in writing to extend or modify the times allowed above in this order for discovery and inspection, provided that the agreed extension or modification does not alter, disrupt, or delay the trial status conference or the timely filing and resolution of pretrial motions. Then the next section says that when the prosecutor is done filing all their discovery material and giving it to the defense, then they're going to need to file a notice with the court saying that they're done providing all their discovery material. And then again, they both have to disclose here. And then it says under new header, motions and notices, it says notice regarding recusal. And it says within 14 days, the government shall file and serve a notice listing each person or non-government entity of which it is aware who now has or will have a financial interest in the subject matter. And that notice shall include each victim of the charged conduct who may be entitled to restitution or any partnership, entities, blah, blah, blah. And it says each party has a continuing obligation to file and serve a notice regarding recusal on learning of any grounds for recusal or disqualification of a judicial officer or counsel. That's weird that they add that last sentence in to this paragraph, which is mostly about serving a notice for entities and people that might have a financial interest. And at the end of that, it's about recusal of judicial officers. Seems like they messed that up. I see a number of misspellings in this thing anyway. It also says within 14 days they are going to provide an estimate to the defendant of how long the trial length is going to be, and they're going to have 30 days, 35 days, all parties shall file and serve all motions with memoranda and certificates and all notices. And they'll also have to file and serve the following pretrial motions. All motions identified here: motions for a bill of particulars, motions for a James Breton or Franks hearing, which, if I recall, is motions to suppress evidence. If there's a false statement or something that's not correctly made, that needs to be motion to be removed now. And of course, a bill of particulars is a written document in which a party has to explain the allegations in his or her complaint or petition in more detail. So all that has to be filed within 35 days. And it says motions in limine are due 14 days before the first day of the trial term. And those are motions discussed outside the presence of a jury. And it means at the start or on the threshold of the trial. And it's usually made to maybe request that certain testimony be excluded from the trial, or it can also be used to get a ruling to allow for the inclusion of evidence. That has to be made 14 days before the first day of the trial term. Jeremy Dewitte loves to file for continuances to get things delayed. You have to file those 2 business days prior to the status conference. If you don't, then the court will presume all parties are ready to proceed to trial. After that, there's still ways to get it continued, but the court doesn't like it necessarily, but they're fine with it. And then it basically says any pretrial motions that you don't file by the deadline must be denied as being untimely. And it says if there are untimely motions, that's fine, but you must set forth good cause for the delay, and then the court will probably allow it. And that has a certificate required for your motions, which says before filing any motion in a criminal case that is not an ex parte motion, the moving party shall confer with counsel for the opposing party in person or by telephone, but not solely by letter, email, or facsimile. And they have to do this in good faith to resolve the issues raised by the motion, and shall include the motion in a statement. No, they shall include in the motion a statement certifying that the moving counsel has conferred with opposing counsel, and that counsel has been unable to resolve the motion by agreement, and that the motion concerns matters which are not covered by the scheduling order. So that's important. So if you want to file a motion, you first have to talk to the other attorney about it and see if you can resolve it before you can even file it with the court. Otherwise, the court's going to look at it and say, why didn't you try to resolve this outside the court? And it says inside the motion, you have to write that you tried to resolve this with the other party. And if you don't do that, the court will deny without prejudice motions filed without the required certificate. So that means you can try to do it again. And it says, except where the certificate specifically timely calls or visits compromising a significant good faith effort by the movant to confer. All right, I'm moving on. You got to look up how to file motions in federal court if you want to go through all that. The next part is the waiver, which basically says if you don't raise your objection or your defense in time, then that constitutes a waiver. So it's basically, in a way, you're waiving your right to raise that defense or objection because you didn't do it in time. But it says a relief from a waiver may be granted for cause on a showing of excusable neglect. The court is very lenient. They want to give you all the options possible. It also says any party that wants to oppose any written motion has 14 days to oppose it after being served with the motion. So again, things happen very fast. If there's a motion, you have 2 weeks to respond. And then it also talks about the jury instructions, and both parties can put forth questions at the court to ask during the venire. Is that how it's pronounced? It's basically a group of potential jurors that are brought into the courtroom during selecting the jury, which is this other word. So it has to be filed 14 days before the first day of the trial term. The next part is demonstrative exhibits. The court requires demonstrative exhibits that parties intend to use in opening statements and closing arguments be given to the opposing counsel no later than 1 full workday prior to the commencement of trial. So you can give those over to the other party at the very beginning of the trial, basically. So any exhibits that are going to be used can just be given to Jeremy Dewitte 1 day before the trial. And then it says here, after the trial, you have 2 weeks to give all the evidence and everything to the clerk. And then they've scheduled a status conference for 2 weeks in advance now, which is when the counsel and defense is going to get together again and make sure that they're ready for trial, which they've scheduled for 1 month and 1 week in advance. So from your initial arraignment, you're going to have a jury trial in 40 days. And we've just gone over the rules of the court that we're going to be seeing Jeremy Dewitte be liable for in his IRS tax evasion trial. Thanks for watching the Jeremy Dewitte Show. Stick around if you like these kind of videos. Make sure you like this video if you've liked it. Comment down below. Let me know what you think. And as always, have yourself a great day.